Over to the United States now, where a major legal battle involving former President Donald Trump has just taken a dramatic turn. A federal judge has dismissed Trump's $15 billion defamation lawsuit against the New York Times. The lawsuit targeted 3 articles and a book authored by Times reporters. Trump claimed the reporting was designed to damage his reputation, but the court did not agree. District Judge Stephen Day rejected the case outright. In his words, the lawsuit was a decidedly improper and impermissible effort to attack Trump's adversaries. That is a striking rebuke, suggesting the court viewed this as political score settling, not a genuine legal claim. Judge Mary Day reinforced the point, declaring that a complaint is not a megaphone for public relations. Together, the rulings framed Trump's lawsuit as something more like a press release than a legal argument. Still, the court left the door slightly open, giving Trump's lawyers 28 days to submit an amended complaint with tighter boundaries. Trump's attorneys have vowed to press on, insisting that the New York Times must be held accountable. But many critics argue this is just the latest example of the former president using lawsuits as weapons against his opponents. Ari Cohn, a lawyer who specializes in First Amendment law and leads tech and legal policy at the Foundation for Individual Rights and Expression, weighed in on the matter. Ari Cohn said, "It is, and we've seen that President Trump has wielded his lawsuits in this way before, down to suing a pollster for publishing a poll that he didn't like under consumer protection ration. The process is the punishment. The goal isn't to win here. It's to subject people who criticize him to unending, expensive, time-consuming and stressful litigation." Cohn's point is clear. The lawsuits may not be about victory in court, but rather about the cost and stress of defending against them. In dismissing the lawsuit, Judge Day criticized Trump's lawyers for filing what looked like a political diatribe disguised as a legal complaint. Ari Cohn explained, "When you have a lawsuit tossed out as being an improper complaint in this manner, you usually have a chance to amend it. So the judge gave them a page limit so that they don't do this press release by complaint before." And the judge is right. We see this tactic consistently, particularly in this politicized age. We see long, laborious complaints that read much more like this general internet gripe than it does an actual lawsuit. So it's somewhat unsurprising and surprising at the same time that a judge finally said enough. That remark highlights the unusual nature of this dismissal. Courts often tolerate political flourishes in legal filings, but this case crossed a line. The New York Times is a powerful institution with vast legal resources. It can afford to fight back against even a high-profile opponent like Donald Trump. But what about other organizations? Smaller outlets, independent journalists, or local media may not have the money or stamina for such fights. Cohn argued that this is where the danger lies. Ari Cohn said, "We just saw the Federal Communications Commission threatened ABC, their affiliate stations, to pull their broadcast licenses to get Jimmy Kimmel off the air, and ABC folded within just a very short period of time, within hours. And ABC, Disney can certainly afford to protect itself. What we're seeing here is institutions that can and should be defending themselves, capitulating just to ease the burden and not have to deal with the pain of actually winning a lawsuit or with regulatory action." His example points to how even massive corporations sometimes buckle under pressure rather than defend their rights. Cohn warned that once big institutions stop standing up for themselves, the consequences trickle down to everyone else. Ari Cohn warned, when institutions won't defend themselves, it's hard to defend them. And once the landslide of erosion of constitutional rights starts, and it always starts with the big cultural institutions, the little guy is going to get crushed ultimately. In other words, if companies like Disney or ABC retreat, then smaller media outlets, freelancers, and content creators, those with the least resources, are left completely exposed. The question is obvious. If these large media giants have the money and legal talent to defend themselves, why don't they? Why fold under pressure so quickly? Ari Cohn responded, "It's actually frankly baffling to me. Sometimes it's in the Paramount-Skydance merger. You saw there's regulatory business before the FCC that makes it a poor business decision to fight back. And Nexstar, which yanked Kimmel, they unsurprisingly have business before the FCC. Sometimes it's a business calculation in that sense. Sometimes it's just spinelessness." My colleague said the other day, you know, a spine is a terrible thing to waste, and it's true. That statement underlines a grim reality. Sometimes it's about protecting corporate interests, and other times it's simply about avoiding conflict, even at the expense of core constitutional protections. If media companies won't always fight, then the courts become the last line of defence for the First Amendment. But will they hold? Ari Cohn reflected, I am optimistic about that. The courts have generally been a pretty good bulwark against intrusions on the First Amendment. That being said, we've seen cracks before. But it's going to take institutions standing up for themselves, because you have to get to court before anything actually matters. And if for every New York Times we have 12 different ABCs and Paramount Sky dances, then we're in a lot of trouble. Cohn's optimism comes with a warning. The courts can only defend free speech when cases make it to trial. If organisations retreat before reaching the courtroom, constitutional protections remain untested and unenforced. At the core of this debate is something bigger than one lawsuit. It's about the cultural commitment to defending free speech in the United States. Ari Cohn concluded, there needs to be a cultural commitment to standing up for free speech, otherwise we're going to get crushed. That line resonates. The First Amendment has long been a defining feature of American democracy, but rights are only as strong as the willingness of people and institutions to exercise and defend them. The dismissal of Trump's lawsuit fits a broader pattern. Throughout his career, Trump has not hesitated to take adversaries to court, often in ways critics describe as heavy-handed or retaliatory. From pollsters to media organisations, his targets are wide-ranging. The consistent theme, according to critics, is not necessarily to win in court, but to make opposition painful, costly and exhausting. For Trump's supporters, these lawsuits are seen as bold attempts to hold media accountable, an effort to fight what they consider bias or unfair reporting. To his critics, the cases are a direct assault on press freedom, a dangerous precedent in which political power is used to intimidate journalists. Judge Day's ruling underscores just how high the stakes are. By sharply dismissing the complaint and imposing stricter filing requirements, the court signalled that it would not serve as a stage for political theatre masquerading as law. The implications go beyond Trump and the New York Times. If legal and regulatory intimidation becomes normalised, then media outlets may begin censoring themselves to avoid costly battles. That, experts warn, could lead to a chilling effect where critical reporting is suppressed, not by censorship, but by fear of litigation. Cohn's analysis suggests that unless both institutions and individuals stand firm, the pressure will erode protections not only for the press, but for everyday Americans exercising free speech. The clash between Donald Trump and the New York Times is about more than one defamation lawsuit. It is about whether powerful political figures can weaponize the legal system to silence critics. It is about whether corporations will stand firm to defend their rights or fold under regulatory pressure. And it is about whether courts remain strong enough to uphold the First Amendment in an increasingly polarized era. The federal court's dismissal may have ended this particular chapter, but the battle over free speech in America continues. Ari Cohn's warning echoes as the last word. There needs to be a cultural commitment to standing up for free speech, otherwise we're going to get crushed.